afternoon, everyone. Kia ora tātou katoa, Ben Hoffman tēnei, and my mahi is at the Whare o Turi o Waikato. Hi everyone, I'm Ben Hoffman from the Community Law Centre, which covers the Waikato, and I'm here to talk to you today about food grants and your rights at work and income, or ESD. I thought we would start with food grants. That's probably the area that folks are most interested in, and so if anyone has to shoot off halfway through or such, then at least you get this. This is designed to be a run through of the highlights of what's in the double-sided A4. The idea of that is for you to hand out to people or go through them with the sheets with the slides on them, and not every slide from this is in there, only the really important ones. That's for you to be like a really fast way of referring to something when you're at work and income with somebody, or you're talking with work and income or such, rather than having to go through all of the written information in the handout, because we know that written information is often sort of, wordly and gets a bit, confusing. Right, so we know that entitlements to food grants are a problem. Kia ora, welcome, just have a seat somewhere. We know that food grant entitlements are a problem, that's why we're here. MSD will say, oh, but we're handing out more food grants than ever before. That might be true, but that doesn't mean that for some people it's not a problem. They decline about 3% of food grants on average nationally, but we know for some people it's much, much worse than that. We know that some people really struggle, like every time they apply for a food grant, it's a struggle. Only about 0.0001% of people who are declined the food grant will legally challenge that decision. And we know that's far too low, and that's one of the, look, I think it'll always be lower than it should for a number of complex reasons, but this is what we're trying to change. So we'll talk about why MSD say no, what the law says about food grants, how to deal with common food grant problems, and how to start the process of formally legally challenging a decision which they make. So why do MSD say no? It's uncommon, and I can say this with certainty, it is uncommon, very uncommon, for the law to actually say no, you are not entitled to what you are asking for, be it a food grant or something else. So, and I'm happy to say this, no should not be the first answer. So, the reasons that MSD say no are generally because they haven't properly investigated the person's situation, they've misapplied the law, or that person has been told by somebody more senior to them to say no. And it's possible, probable, somewhere in between, that the person who's telling that person to say no has not, hi, welcome, just to have a seat somewhere, that's fine. It's quite likely that if the case manager is being told by someone more senior to them to decline the person, that manager or trainer or whoever hasn't properly themselves investigated the person's situation, or maybe they've misapplied the law. And I can say this dealing with thousands of people with all sorts of problems at MSD, that the first two are usually the reason why they've been told no. So it's the law that sets out your entitlements. the Social Security Act of 1964, no, the Social Security Act of 2018, but don't worry about that, it's just the old version rewritten, so nothing's actually changed. It's the Social Security Act, a law passed by Parliament. The government has said this is what people are entitled to in these situations. It's really important for people to understand that work and income and MSD, because various other services of MSD also do food grant applications. It's not just a work and income service. It's the law that sets out the entitlements. MSD are not a power unto themselves who can just do what they like legally unchecked. The Social Security Act sets out the criteria for entitlement, including for things like food grants. The job of MSD is to take those criteria, look at the person's situation, and then see, well, can we marry the two together? If the answer is yes, then they approve it, and if the answer is no, then they decline it. And again, most problems are because MSD may not have applied the law properly. Staff do have a manual. It's called MAP, and it's freely available on the internet, but it is just, it's a guide for staff, and it does not replace the law. So here's the flow diagram version of that. The Social Security Act sets out entitlements. For most criteria, this one's not in the accounts. For most criteria, the Act will specify the situations that meet that criteria. For some, they don't, and MSD have the power to exercise good judgment. And that's particularly the case for food grants. And then if they think all the criteria are met, they will approve the application. If they don't, they'll decline it. And regardless of whether or not the person's approved or declined, they have the formal legal right to independently challenge that decision. Because, and I know this might sound really bizarre, but there are some circumstances where having an application approved still gives rise to the need to challenge that decision. For example, how much food grant, or when to grant a benefit from. And feel free to ask questions as we go through. So, oops, that doesn't work. There we go. Does this make sense? Can everybody? Cool. Is there anybody who's not sure about this? Cool. Okay, good. Clearly, I'm better at explaining things than I thought. Right. So, food. Food is one type of something called a special needs grant. There are lots of other different types of special needs grants as well, but food is the main one which we're interested in here. There are general eligibility criteria for any special needs grant, which we'll talk about, and then there are some specific criteria for food grants. I know this list seems really long and oh my gosh, all the person wants is some food, all these hoops to jump through, but that's what the law says. And look, for 99% of the folks that do help, the general criteria will almost always be met, particularly if they're a beneficiary. But I don't have to be. So you do not have to be in receipt of a main benefit. So, for example, the job seeker or sole parent or whatever, you don't have to be on a benefit to get a food grant. I think I missed that in here somewhere. That's quite important. You can be a student on a student allowance. You can be a superannuitant or on veterans pension, or you can just be independently on a low income through some other means, or you can be a student, I've said student, you don't have to be someone on a benefit. So The general eligibility criteria for a special needs grant are residence, means, which means income and assets, not having a sanction or a 13-week non-entitlement on your benefit, and you should have, but not must, have done any budgeting or money management steps you've agreed to with MSD beforehand. Right, so what these mean are somebody must be a citizen, a permanent resident, or on a resident visa. So any one of those three. If you're a refugee, an asylum seeker, or you're applying for a residence class visa and you have an exception under Section 205 of the Social Security Act, and you're granted an emergency benefit, you're not eligible for these. And that's simply because the Social Security Act says the only thing you can get is an emergency benefit. So that's quite an important distinction. You also must consider New Zealand your permanent home, and that's called ordinarily resident or ordinary resident. And there's a set of criteria in which you have a look at for that, but I'm not going to run through it because I wouldn't imagine that anybody who you folks see is not ordinarily resident in New Zealand. You must meet an income test and a cash assets test. I don't like using the word test because it's not like a test you pass or you fail. It's not like a written test. There's a limit, shall we say, and you must not have a sanction on your benefit, which is it being suspended, reduced, suspended, or cancelled for an obligation failure. Everybody familiar with what that means? Good. That's unfortunate because you've obviously seen people who have had those. It's a shame. Or you must not have a 13-week non-entitlement. This is the one for leaving a job voluntarily without a good and sufficient reason or being fired for misconduct. So everybody, is there anybody here that's not familiar with that? Just hand up. Okay, one brave person in the back. I never like sort of sticking my hand up at these things. I was, is there someone else who's going to or not? It's exactly what I just said. So if somebody leaves their job voluntarily without a good reason, that's the important part, or they are fired, Work and Income can impose a 13-week non-entitlement to essentially anything. There's one or two exceptions, but that's not for here. So if you see somebody who has one of these two, it's no good arguing, Work and Income should give them a food grant, because they can't, because these are mandatory. The easiest way, the smart way, is to deal with the non-entitlement or the sanction, which probably means sending them to me. And as long as you meet those, five, you should, but not must, have completed any budgeting or money management steps. So the first 5 are mandatory. Work and Income, MSD have no discretion in the law. They have to look at the person's situation and see, well, do these criteria apply or not? But that's not the same as having a genuine ability to not apply them if it fits that person's circumstances. So only the last one is truly discretionary, where Work and Income can say, oh no, look, you haven't done this, but that's okay. Yep.
If you take voluntary redundancy because there's been a change in work situation because of COVID-19, say, and your market has dropped away and your employer can't afford to keep you on.
No, so that
that part of this or not really?
No. So the question was, if someone is voluntarily made redundant, do they get a 13-week non-entitlement? And the answer is no. It's voluntary. It's voluntarily resigning from your job. Like, oh, I don't like my boss. Bugger you, I'm going to go on the dole. Or it's being fired for misconduct. These are the income limits. So these figures are before tax. In the week the person needs a food grant, they do not include, so this is the important part, they do not include any benefit, allowance, super, or a veteran's pension. They do not include working for families or the Best Start tax credit. They do not include some, but not all child support. And they do not include an independence allowance from ACC. Those are the big ones that are not included in these figures. You're looking at these thinking, gosh, these figures are really, really, really low. And you're right, because they haven't been significantly updated since 2005, 2007, one of the two. And so, as the minimum wage has gone up, they've excluded more working folks. What a cash asset means is money which you can readily use instead of a food grant in order to buy food, but it has to be appropriate, sensible. I've saved up some money so I can get some new clothes for my child. That's not sensible to use. I've saved up to get some new tyres for my Land Walker. That's not sensible to use. I've got money sitting in the bank and I have no purpose planned for it, but I just don't feel like using it. And I should get a food grant instead. That probably is sensible to use, and I think I would have a hard time arguing that it's not. Does everyone see the distinction? Good. But a cash asset does not include back payments or gratia payments from MSD. So if MSD, oh look, you know, we're terribly sorry, we have found out that we owe you some money and we back pay you, that's not a cash asset for 12 months. These are the three which are probably more important for you folks. The specific criteria to get a food grant. So, to get a food grant is assuming that you meet these. There are three criteria to get a food grant. Well, three and a half, four. You must need to buy food immediately. You must not have enough money to buy food. And your lack of food money must be caused by an essential expense. And if you've had over a certain amount, your essential expense must be caused by what's called an exceptional circumstance. Now, we'll explain this. It's all right. You do not need an emergency, and you do not need something unexpected. The fact that you have something which is expected doesn't mean that you can't get a food grant. There's no list of essential expenses. This is something where MSD in law has to carefully exercise their good judgment and look at, for this person in their individual circumstances, was that an essential expense? And this is where some of the problems, oh no, look, that wasn't essential. Well, what's essential for me, and for you, and for the person in front of you who's hungry, are likely radically different. And MSD must carefully consider that person's individual circumstances, because the government or the Parliament can't write a list, because there is no list, because it's so different between people. And exceptional, there is no list of exceptional circumstances, because again, the Parliament, they would never write a list of all of the circumstances. It means something that is unusual or not typical. So unusual or not typical, but it does not have to be an emergency. It does not have to be unexpected. So that's really it. And it means that in law, there's not a true limit on the amount of food grants that someone can have. However, where the problem comes in is that after this amount of food grants, within 6 months, the essential expense or the essential cost has to be caused by something exceptional, unusual or not typical. So, not that it has to be caused by something exceptional, unusual or not typical. It has to be caused by an exceptional circumstance, which means something unusual or something that is not typical. And it has to be not typical or unusual for that person in their individual circumstances. What MSD tell their staff is that it has to be something which sets that person apart from other people in a similar situation. And frankly, I think that's legal fiction. It should be that person's individual circumstances. So the fact that it might not be exceptional for that person over there who's also on a benefit, I really do think that they would legally struggle to have that argument accepted. And now, you're probably about to ask me, but Ben, these amounts are so ridiculously low. Where did these come from and who came up with them? And the answer is, these amounts have not changed since Christmas 1994. That is why they are so low. So these are actually set in 1994 dollars. When I was 9 years old, and I was about this tall, and I was less round, so for me, as a single childless man, in 1994, I could probably get, 4 food grants in 6 months, and I'd be sweet, because I could probably live on $50 food a week. When I was a poor student in the mid noughties, I could live on $50 a week, no worries. So in 1994, it would have been probably, much easier. That's why the numbers are so low, because they haven't changed in like 25 years. Some people will say, oh yes, but it got changed from 12 months to 6 months. And yes, I acknowledge it did. That probably didn't really help many people that we deal with, who need food grants on a chronically ongoing basis, mainly because their whare is taking 70% of their income. So what this means is there's no limit on the number of grants. The only catch is that once you've used up this amount in 6 months, which most people have, and most people do, really, really easily, it means that your essential expense which you spent your food money on, has to be caused by something exceptional. So there's no such thing as too many grants, and this no entitlement left is an absolute myth. When work and income say, oh, but you've got no entitlement left, what they mean is you've used up this normal amount, you need an exceptional circumstance, or you need something unusual or not typical. But the way, being recorded, so I'll choose my words carefully. The way that work and income teach their staff, or the way that MSD teach their staff, obviously has them confused about the fact that there really is no such thing as no entitlement left. If you meet the criteria, including an exceptional circumstance if needed, there is no non-entitlement. In law, it just doesn't exist. So, oops. See, I'm all fun today. So this, now, look, I know that me standing up here droning on is not, may not work for some people. So this is a flowchart version of that. I'm hoping I'll put the flowchart in the handout, but I might not. No. Does anybody have any questions about this? Say that again, sorry? So the question is whether the person has to have proof of exceptional circumstances. The law says that MSD can ask for reasonable supporting evidence. So it would depend on the person and their situation. Like some people, for example, who are in what's called the low trust group because they've been convicted of benefit fraud, do have to provide more proof than someone who doesn't. It comes down to the case manager or the staff member carefully exercising good judgment about whether or not to accept what the person's telling them, or whether something in there sounds unusual, shall we say, and so they've asked for some proof. But no, there's no list that says you must have proof in these circumstances and not in others, no. Anybody else have any questions? Yeah?
Question. I was just going to say, I know of a couple of people that have run through of late.
Yeah.
And they're either cut off because they're waiting too long.
Yeah.
Or told they'll get a call back and wait a couple of days for that.
So the question was about waiting lots of time or having trouble with the 0800 number. They should go to the nearest MSD office. The offices are open and accepting people. So if that's look, we know the wait times are really, really long and that some people have to have a call back and some people don't. If the person is desperately hungry now, go to MSD. Or if you know the manager, ring the manager. Down in the back.
Yeah, even I took a few times to into the office.
Yeah.
And they were stopped going to the door because they don't have an appointment.
That shouldn't, so nobody should be getting stopped at the door anymore. That shouldn't be happening under alert level 1. If it does, lodge a complaint online is my advice, because I've had very strong words from MSD that it shouldn't be happening. Okay, let's move on. So what we see now so much is not a person being declined a food grant, but we're still seeing people given really unreasonable amounts of food grant. So the Social Security Appeal Authority, which is exactly what it sounds like, it's judicial tribunal who independently adjudicates work and income disputes about Social Security Act decisions, has said that MSD should be using the Otago Food Survey. The Otago Food Survey is published by the Department of Human Nutrition at the University of Otago. And they are the best experts on what sort of the average amount of money that certain people will spend on food a week. And these are the amounts they've come up with. I didn't come up with them. I'm happy to get very stroppy at these. I did not come up with these amounts. These are what the nutritional experts say is the average cost of food for 1 week for the people listed. Now, it is just an average. Okay. Okay. Yeah. Again, I didn't come up with these numbers. I'm sort of waiting for them to hurl something at me. It hasn't happened yet, but I'm waiting for it. The trick to using this is to add these numbers together. So, again, for me, it's pretty simple. As a single child man, I say that I need a minimum of $92 a week for food, and that's pretty okay. If I got a food grant of $90, I can make it stretch. But if you've got some other folks in your family, just add these numbers together. And this is the minimum that work and income should be offering for 1 week of food. Because in exercising their power to make a decision under the Social Security Act, they have to look at what's relevant. Well, this is what the experts have said the average cost is. So they really shouldn't be departing from that downward. So they shouldn't be lowering it unless the person, clearly only needs food for a couple of days or something. And it doesn't include non-food items, so soap, toiletries, shampoo, other things, the hygiene products, we'll say. And it must consider the person's individual circumstances. It's particularly a problem with people in emergency housing who've only got an any-weeny bar fridge, who can't do a week's shop, and who are going to need, 30 or 50 bucks more because they can't store all of the food. And I have to be honest, some people, through no fault of their own, some people just don't have the cooking and the meal planning and the budgeting skills that folks once learnt at home. And so if they need more for that reason, then MSD must consider that when making a decision on how much to give someone. So I've actually had really good success with this. I saw them offer a mum, a dad, and 3 kids, I think, $200 a week for a week's food, and I just went, oh no. And this was back in the day of face-to-face appointments, and so I just whipped out my phone and went tap, 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 and sort of showed it to the case manager that it was about $370, I think. And I said, well, here's what this says. If you still want to offer them this much, then you need to explain how you're exercising your discretion to override what the nutritional experts say is the average minimum required. And she just went, oh, so you want $370, whatever it was? And I said, well, yeah. And she goes, oh, yes, of course.
More often than not, they'll say, you're getting paid every couple of days, so we're cutting that all down and you get $40 short of you.
So, The question was, why do MSDs say to people, oh, you're being paid in a few days and so you get less? Well, that may not be unreasonable because these are for a week's worth of food. You do have to, really good trick with that is to look at how overdrawn the person is in their bank account. How much have they actually spent this week on whatever was exceptional or essential? And so if they're in negative in their bank account, well, when they get paid this week, they're going to be in, you know, have less disposable income. So that's how I would get around that. But in law, it's not unreasonable to offer someone less if they're getting paid in a couple of days and they've got their whole normal amount of disposable income available.
Providing that case managers.
Yes, so you're right in that staff need to be having good quality discussions with people and understanding all of their individual circumstances, and that's an absolute must because one of the legal requirements of exercising discretion is that you must consider all of the relevant circumstances. So in the interest of time, I'm not going to run through this, but these on the left are some common things that we commonly hear that MSD say to people, commonly, when they are discussing food grants with people, and on the right-hand side is what we suggest the person says back to them, with the caveat that it must be true. If one of these doesn't apply, then the person can't say it because it's not true. So we're not telling people to lie because that's benefit fraud. But what we're telling them to do is, here are some suggestions of things to overcome what working income or what MSD say to you. And in 99% of cases, it's more than likely that these are true. If these don't work, so if these don't work, and the person's told no, well, so assuming that you've used this and the person's said no, which is the first one here. So if that doesn't work, firmly but politely insist that a manager or a more senior person checks that person's decision. And it should be the person who is applying being able to speak with that more senior person, because otherwise, how do we know that what the staff member has told the more senior person, or will tell them, is actually accurate? The person needs to speak with the applicant needs to speak with the more senior person themselves. And if that just doesn't work, then you just accept what they offer you, accept $50 in food grant or accept a food bank letter, and apply for a review of decision, which we'll talk about when we do our rights with the MSD directly after this. That's my attempt at making an infographic. It's a bit wordly. It's not as sexy as some of the infographics you see, but it's a work in progress. And once we've fixed it up and it's sexy looking, we'll get it out to you. Questions? Just shout them out, that's fine.
Are food grants repayable? Do you have to pay them?
Oh, no, God, no. No, never. Never, ever. If somebody, it terrifies me that you've asked, because I'm thinking, oh my gosh, what have the MSD told people? No, so food grants are never repayable, ever. If you know of somebody who's having to repay a food grant, get that person into me straight away, man, because there's something, because if that's true, then something could well have gone horribly wrong. Other questions, just shout them out, it's okay.
So the exceptional circumstance, for the first 6 months,
Yeah.
do you not need exceptional circumstance?
No, it's not for the first 6 months. It's here we go. You only need an exceptional circumstance after you've used up this amount within 6 months. So you could have, let's just use the single without children example. If you have a food grant of $100 in January, and then if you have if you have $50 in July, which is 7 months later, it doesn't matter when you get that extra $50, which you have left of your normal allowance. So the exceptional circumstance only comes in after you've had this amount of food grants in 6 months. And the problem with the way the law is currently applied, and I use that word deliberately because I'm not sure if it's being applied in the way that it was intended, but it may very well be, is that the 6 months resets. So if you have a grant in January, it resets, and then you have 6 months until, let's say, the end of June. And then if you get one in March, the 6 months resets, and then add 6 to 3 is 9, which is September, and it just, don't worry about that, though. Don't worry about that, because the vast majority of the folks that we see have used well more than this, and so it doesn't, if you sit there and try, 6 months and add this and how much, it's just too confusing.
But can the reason for getting that to come to say single without children,
Yeah.
can it be I just have a very big power bill?
Yeah,
Or
yeah, absolutely.
My contents insurance came and I paid it. So you don't, that's, because you're not saying you can be exceptional. You can just.
No, so, there's no list of what's an essential expense or essential expense caused by exceptional circumstances. Because when Parliament are sitting down and writing the law, they can't think, oh gosh, well, there's Sally over here and Sue over here and, Bill and Ben over here. What's exceptional for them? Because the list, could be completely different. So, so as long as you can show it was essential for the person, and the easiest way of showing that is by saying, well, if the person didn't pay this, right now, something bad would happen. Something bad would happen. And it doesn't have to be the end of the world, homelessness and bankruptcy. It just has to be, well, if they didn't pay their power bill by this date, they got late payment penalty, or if they didn't give, their sister $50 to go to, I don't know, thanks, the doctor, then she couldn't go to the doctor. Some MSD staff I've seen in the past, they like to morally judge people and say, oh, well, you didn't have to give your sister that $50. She could could have come and seen us. Or, you should have made better choices. And, okay, there's a chance that maybe that was true, but that doesn't matter. I say that you have to look at the whole of that person's circumstances. And there's no clause in the law that says you can be, on the moral high ground about these sorts of things. Now, look, in fairness, I haven't seen that for a long time, but I have seen it. So it doesn't matter, It's about painting a picture about why this was essential or why it was something exceptional. Any other questions, or we'll move on to the next set?
Unexpected
Yeah.
and exceptional.
Yeah.
They're pretty much the same, aren't they?
Yeah. So, well, actually, sorry, no. No. Very importantly, no. And sorry, I don't mean to be pointing my finger at you like that. No, so it's not unexpected, it's unusual or not typical. There's a really fine difference between something being unusual. So just because something is unusual doesn't mean it's not expected. You expected to come here and hear me present this afternoon. Just because I might be a bit of an unusual chap doesn't mean that it's unexpected. Although that probably was. And it doesn't have, so the key thing is it's unusual. Yes. Unusual or not typical. It doesn't have to be unexpected, because the law doesn't say this must be an emergency or this must be unexpected. It used to. Prior to 1994, it did. It actually said food grants are for emergencies only. How that worked, I'm not sure. I'm glad we aren't having that discussion now, because that's certainly a much higher threshold. So it's unusual or not typical. An example of this being, my power bill was twice as high this month because I've been home sick for 2 weeks. That's not unexpected. I could reasonably sit there and sort of, foresee that, gosh, I've been home running the heater and the electric blanket and having 3 showers a day because I've been really crook. I could reasonably expect that, bang, I've got this, large power bill. But that doesn't mean it's but that doesn't mean that it's typical. So that's the best example that I can think of for that. And these are the sorts of things where we see staff not applying the law properly because they've, well, I can't say they're biased, but they're, although there may be some unconscious bias in there, sure. But that's actually a really good example of where staff get the law wrong, because you look at it and go, oh, well, it's unusual. Oh, so it has to be unexpected, because unusual things are unexpected. And that might be quite true, but there are also unusual things which are expected, like the example of the high power bill.
Are you expected to provide evidence when they ask?
You give no money.
Or you paid this, or you repaired a window, or whatever you did?
So the question is about supporting evidence. Somebody in the front asked that before. The answer is, it depends. The law says MSD can ask for reasonable supporting evidence, but it's a judgment call. Is what the person telling me sound reasonable? If it does, I would accept it on what they tell me. If it you know, but if it's the third window I've had repaired in my house this month, well, I'd be looking at that going, well, that doesn't sound reasonable. So it depends on the person and the circumstance. And some people do have to provide supporting evidence more than other people, and they are what's called low trust, because primarily they've been convicted of benefit fraud.
Do they have to prove they have no money?
Does the person have to prove they have no money? Again, no. There's no line in the law that says you must prove you have no money. And again, because most appointments are because most things are on the phone now, then I would say no. I'd find it really unusual if someone said, well, you have to prove how much money you don't have, you know. I'd find that really unusual. But depending on the circumstances, it may be perfectly legally reasonable for them to ask. But I'd find that really unusual if that happened. So I'm interested in hearing from you guys for a minute. What sort of experiences are we having here and there about helping folks with food grants? Just shout it out.
We had one patient that couldn't get an appointment for 2 weeks. She needed a food grant. Yeah, no.
Okay.
I mean, we probably should have just taken it down.
Yes. Yes. So you should be getting a food grant. So when someone says, I need a food grant, MSD's standard is to respond within 1 business day. So you shouldn't be, so most people can get food grants by calling the 0800 number. Some people can get food grants on My MSD. It depends whether or not you've used up your, normal allotment or not. So try My MSD. For most of the people that we see, that probably won't work, but you can try. Ring the 0800 number. The best time to ring the 0800 number is early in the morning or at lunchtime. And by early, I mean 7 o'clock in the morning when they first open. Most people can get a food grant approved through the person who answers the 0800 number. If that doesn't happen, the person will be put into a list for a callback, and it could be anyone from anywhere in New Zealand.
3 days.
But if you're but if that person desperately needs food, get them into the work, you know, get them into their closest working income office.
I just wanted to MSD office and they asked for this question. And I said, no, she's needing food. Are you prepared to wait? Yes, we're prepared to wait.
Yep.
And so we've got to see someone within half an hour.
Yep. So the person always has the option of waiting to see somebody at MSD. It's not ideal, but if you're hungry and you need kai, then I'd be bloody well. I'd be waiting all day if I could, if I had to. Right.
I had a patient that was declined and told to get a food basket.
So what? So do you know why your person was declined?
Well, I think apparently they've used up the.
Oh, you've got no entitlement left. Yes. Well, no entitlement left is legal fiction, and not the good kind like John Grisham writes. And responding to that, just, you know, nicely and politely say, well, look, actually, in law, there's no such thing. And show them that handout. I have had, and I don't mean to sound smart because I really don't, we've had very good success sending people, because we can't go to every work and income appointment or every food grant application with everybody who contacts us. I would need 6 clones, and well, actually no, I'd need 14 clones for the 14 work and income offices that we cover, and one of them is bad enough. we've had very good success helping people to use these and use the handout, the double-sided A4 that we've handed you. We've had very good success with that.
Can I just ask quickly before I forget, what happens when a manager declines to meet? When you've been declined your food grant, you've
Yep.
had enough, we asked to meet with the manager to say, look, can we sit down and nut out
Yeah,
with this person because they're having to come in quite often?
Yep.
And the manager declined as well. Would not come and see us, only the worker spoken has said no, even by email. Said she comes in far too often, needs far too much help.
oh, so that's something that, that is an utter myth. There is no such thing as too much help. If the person is entitled to it, the job of MSD as what's called an executive department of the government is to give that person what they're bloody entitled to.
Is there a list of things they can and cannot apply for?
No. No. So,
It gets worse.
yeah.
She's telling porkies.
You can't just keep asking for food grants.
No.
You've had too many. You can't keep coming here and asking for them. Now, I've actually seen a manager say that to somebody in a really nice way. But look, you just can't keep coming and asking for these. And she wasn't being horrible. She was just saying her understanding of how the law works. And the way to respond to that is just, well, actually, the law says each time I'm entitled, I can have one. Because that's true. That's what I would say. That's what I would say back to them. Because that's true. Is there anything else about food grants, or we'll move on?
Well, just how old are the Otago guidelines?
These were last done in 2019, I think. And they're updated every year, every couple of years. Have a Google. And if someone knows of something better than the Otago food study, I'd be really keen to hear about it. Because I can't think of, I don't know of any better scientific research into the cost of food for certain people for a week. But I'd be really keen to hear it. Right, let's move on to your rights with MSD. How we end up in this situation, people want to benefit have rights. I mean, how they can no, heaven forfend. Right. So here's a list. I'll see if I can rattle them off without looking at. The first one's always a shocker. You must be told what you are entitled to. Must be told. It is not optional. You must be told. You also must be helped to apply for your entitlements. Must. It is not optional. If those are not done and you were entitled to something, mainly a benefit, but not excluding some of like the one-off help and things. If you were if you were entitled to something and you did not receive it because of MSD error, you can get that payment backdated. I have gotten tens of thousands of dollars for people doing that. You have the right to legally challenge any decision that MSD make through a review and appeal process. Very, again, something like 0.001% of people actually do it.
Because they drag it out so long.
Yes, we know that's a problem. Yes, we know that's a problem. They must send you a warning before they sanction your benefit. That might not be happening at the moment because of COVID. I don't think they're doing any new obligation failures. They restart things at various times, which they've stopped, but I'm not sure of that at the moment. Your weekly repayments for money you owe the department must not cause you serious hardship, and we can talk about that in a second. You have the right to remain silent and to get legal help if you're being investigated for benefit fraud. It is very important. You have a right to copies of your personal information under the Privacy Act, and you have the right to have a support person present with you when dealing with MSD. We will run through some of these in more detail, but please just shout out questions, that's fine.
Can I just ask if you've got a right to be informed of your entitlements?
Yes.
It's very hard to prove it. You make a phone call to them and say, am I entitled to this? And they say no.
So the question,
don't bother applying for anything because they've just told you your phone number.
yeah. So the question was, how do I prove if I've been wrongfully told I wasn't entitled to something? It can be tricky. We know that the quality of record keeping by MSD staff is quite poor. As long as we can prove on the balance of probabilities, so more likely than not, it happened. So there was an interaction, a phone call was made on this date, it will be in the record. There was an appointment on this date, because appointments are in the computer. A form was handed over and something, look, as long as we can prove that that there was some interaction with MSD, because particularly if we're legally challenging a decision not to backdate something based on alleged error on their part, we haven't found that to be much of a problem. I do have a slide on that at the end, so we'll continue. The questions about recording phone calls, yes, they do record phone calls, but they only record phone calls for they store the recordings for approximately 3 months. But that doesn't mean that there won't be a record of the phone call. Even if there's no record of the voice of the actual discussion, there should still be a record that that phone call was made, or there will be a note of the phone call which the staff people made. Or you could potentially look at the person's phone records. That's actually something I haven't had to do before, but that's getting a bit technical, but yeah, so yeah, after 3 months. So the reverse of these is on MSD. So you must be told your entitlements. It is a little bit of a two-way street. The person has to tell of their circumstances or the situation they need help with, even in very broad terms. They don't have to say, my circumstances are blah, 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 and I need help with blah, 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 because most people don't do that. They just, certainly, if I stood at the work and income office and went, no, they'd probably trespass me. No, I'm being facetious. So the person has to just let anybody at MSD know of their circumstances or the situation that they need help with. What MSD must do, it is not optional. They must then inform the person of all of the potential entitlements for that situation or for that need. It might not be the exact person that they're discussing it with, so it might not be the person on the 0800 number, or if you've run up for a food grant and there's someone from the student allowance department, and there's somebody who's hopped in to help out with food grants from the student allowance processing unit, because they do, that person might not have any understanding of anything else benefit related except how to process food grants. And that's true. There are some staff who, as far as the benefit staff goes, all they know how to do is food grants, because that's where the highest need is, and so that's what they've been trained on, in addition to their other work, which might be completely different, for example. But they would need to do something like make an appointment for that person to come in and sit down and talk to somebody, because again, the rules, the High Court has said they generally have to be proactive. So once a person says what they need help with, or their circumstances, they must be told every possible thing that they are entitled to. It's that simple. It really is. And if it doesn't happen, which is a common problem, which I see, you can apply, I assume you can apply to backdate what that person's entitled to. The other half of this is that you must be allowed to apply for what you're entitled to. In law, the threshold of an application is the same. Making work and income aware, or making MSD aware of your entitlements. No, making MSD aware of your situation, your circumstances, your needs, in a way which says these are what you need help with. I don't have enough money to live every week. That wouldn't cut it. But I need a food grant this week because I've had to buy extra nappies for my incontinent child who's got some incontinence problem. That is an oral application for child disability allowance, supported living payment caring, and maybe a non-recoverable health special needs grant to replace soiled sheets and bedding, and maybe some other things that I can't think of off the top of my head. And they must actually help you to apply. They can't just say, oh, you can go and fill that form out over there on the computer if you're blind, or if you're computer illiterate or something. They must actually provide you a paper form if you need one. A constant chronic problem that folks tell me, oh, MSD said there are no paper forms anymore. That is utter legal fiction. You can get some of the paper forms off the website. If the office won't give them to you, just ring the 0800 number. The 0800 number will post them out to you. But they must help you to apply, including providing an application form. And they must give you as much help as reasonable for your individual circumstances. What that means is they can't just say, oh no, we gave you a form and, you know, we can wash our hands of you. That's not true. They must help you to fill the form out, to get the show you what supporting evidence is needed. If you need more help than most folks because of health or literacy or understanding or anything like that, then they must give that to you. And if this is not done, you can apply to backdate something that you're eligible for. Usually these two go hand in hand. Usually we sort of see half of the time the person wasn't told, and then half of the time the person was told, but they were told to apply online and they couldn't, or they were told to, here's an application form, and just left to their own devices. If either of those things aren't done, you can apply to back pay something you were eligible for. And we've got tens of thousands of dollars for people using this. It's great, absolutely great. Best section of the Social Security Act. You can apply to backdate something you were eligible for but didn't receive. This is most common with something called child disability, well, in our experience. It's most common for child disability allowance or working out the most financially advantageous arrangement that's not necessarily large in words for a Tuesday afternoon. I know I can't think of a simpler way of saying it. Working out the which combination of benefits gives someone caring for another person's child because of a family breakdown or because the parents have died or are infirmed. It's a very old word. Medically unable to care for the children. Because we see people who are not on the right arrangement, and so we say that it should this should extend to working out the best arrangement for somebody if there's more than one possibility, and we haven't had the lawyers at MSD disagree with us yet. They haven't necessarily completely agreed with me on paper, but they haven't said no, that we don't think that. I think it'd be pretty extraordinary if they did. Please get someone who you think this applies to come and see us. This is most common with, I've been telling working income for years about my disabled child, and they never told me to apply for child disability allowance. It was only that then person at community law, or it was my cousin who gets it, or my social worker, or my paediatrician that told me, years later. Really common. I've got 3 or 4 or 5 of them at the moment. Really common. So please bring someone to us if you think this applies. If we talk to somebody about their, if we check their entitlements, we will actually check whether or not this applies or not, because we know it's a problem. Right, any questions about that?
Quick question.
Yeah, sure.
Child disability.
Yes.
So I've got someone who applied and they said she has to wait for a formal diagnosis.
No, so the question was, do I need a diagnosis to get child disability allowance? And the answer is no.
Really?
You do not.
Oh, I've been seeing someone here. He's waited over a year for CDC, and now we're waiting for the next step.
Right.
So
Try this.
I'll write it down. Never mind.
All right.
I don't want to miss a beat.
All right. I've never actually liked beets. It's horrible to mush and silver beet and Brussels sprouts.
Yeah.
Exercise that right to silence, Get the GP or the appropriate specialist, for example, paediatrician, to just write a note that says these are the sort of the symptoms and the challenges which the child has, and because of this, collection of symptoms, they need either frequent attention to deal with their bodily functions, or regular supervision to avoid substantial danger. You've really put me on the spot here, because the third one is frequent attention that they and any three of those, and I might have gotten the words the wrong way around, as to whether it's frequent or regular. Probably shouldn't have offered to do that when I'm being recorded. Whichever three of those they have to need them solely because of their health condition, or in this case health situation.
Health/intellectual.
Yep, fine. Yep. Solely because of their health situation, because they can't say the health condition because the condition is unknown. If you have problems with that, you also want it granted from when they first approached Work and Income and told them. If that doesn't work,
The doctor did send in a little note and they wouldn't accept it.
try that. If it doesn't work, bring the person to me, okay? We close on the 23rd and we are back on the 18th. Right, yeah? Okay. So how to challenge MSD? You have the right to formally challenge every decision that Work and Income makes. Independent review, independent of the people who made the decision, and then above that, completely legally independent of MSD. Very few people do this, only about 0.001%, as I've said before. Very few people, or even less people, will challenge a food grant decision. Don't be discouraged or dissuaded from dealing with, from challenging MSD. Just because somebody in MSD decided something doesn't mean that that's final. They're not a law unto themselves.
I've got another question though.
Yeah,
Just one more thing to do. The case manager
yeah.
has asked a few people I know, but this particular one, she had to write down a daily thing that to prove why she would need the child disability for her child. Like
Oh, the
what
extra
is
care and
different.
attention, you mean?
Yeah, what is different? She had to write it in quite detailed.
I've not seen them ask somebody for that.
Yeah.
But if they're struggling to determine entitlement, that is not that's not an unreasonable way of doing it. That's actually it's unusual, but it could very well be that they were simply struggling to determine entitlement, and that's what they asked for. Now, that's actually reasonably creative, which means it's unusual, but it shouldn't be every person, no. So, don't be dissuaded from challenging MSD. Yes, they might be a department of the government, and yes, they might be the one that pays the person's income, but that doesn't mean that you have to accept what they say. If you don't like what MSD decide, then apply for a review. That's the message I'll give to you. You should ideally apply within 3 months of the date of being told of the decision, but you can apply later. But we discourage people from waiting longer than 3 months because it gets tricky. If there was a good reason which stopped them from applying, hey, I was in a coma for 3 months, well, that's fine. If something else happened, then we'll look at it. But and look, most people applying for a review actually can't wait 3 months to sort of, oh, okay, it's been 3 months and I apply for a review now. We know that people get distracted and have, lives and caring responsibilities and things. And some people are just bloody scared of MSD. Let's be really honest. But it doesn't mean that you shouldn't challenge them.
Excuse me,
Yeah.
if you have challenged them,
Yeah.
is it very reasonable to wait more than 3 months for a response?
That would be unusual, but not impossible, depending on the complexity of what the person is reviewing. If the person's really struggling with it, just get them in to see us. Right. Should stop offering it. Right. Most people have appointments on the phone, so it's gone are the days where you can just ask for a form at the Work and Income Office because you're there already. But the easiest way to do it, or do whichever one of these is easiest for you. Or I would recommend actually just using the online form. If you're supporting somebody and you're there, then you can just use the online form. That's probably the easiest way of doing it. It saves having to go to MSD and da-de-da, and it saves emailing the case officer and the case officer never gets back to you. So either use the online form or use the email address. And that is not a space, it's an underscore. So it's @reviews or helpline_work and income at MSD. If you use the online form, that gets sent to the helpline_work and income unit anyway. But I would do one of those if you're not at a Work and Income office. If you're at a Work and Income office, then just ask for a review decision form. But you don't have to use a form. It can be a note. It's fine. But if you do hand something over, get a date stamped copy. Yeah. Okay. That's the process. If the person's at the second stage where it has to go to a review meeting, please send them in to us to get some help. MSD must send you a warning before sanctioning your benefit. Your repayments to MSD must not cause undue hardship. These are all myths which have no basis in law. If the rate of repayment which MSD agreed to let you pay is too high still, even after lowering it, apply for a review. Benefit fraud is a specific set of serious crimes. If a person is suspected of fraud, an investigator will contact them. That person is under no circumstances to speak with the MSD fraud unit unless you have a lawyer or a good benefit advocate present. Not your mum, not your friend, someone who is going to be able to understand what's happening and keep you from saying something which you shouldn't, which may prejudice your position unknowingly or such. These people are the benefit police. Think of them like you would the police. If the police turned up, would you really talk to the police? No. Except for saying hi in the supermarket as I do. Just say that without the police. But don't let these people into the fraud process without help. And these are some practical tips to deal with MSD. These really should keep most problems from arising or have a good foundation for us helping with the more complex stuff if they come to us. And any questions about any of that?
Does this apply to YPP?
Yes. This applies to youth payment and young parent payment, and also to the runanga and the whananga who administer them here, because they are in law social security benefits. So all the same stuff applies. Yeah. The only difference is te runanga and the whananga do not actually have the power to make decisions under the Social Security Act. They get the information and send it off to the youth unit in Mangere. But yes, all the same stuff applies. Any other questions? Surprise. Was there one up the back here?
Is there a limit to what, Working Income New Zealand can take from your benefit for your total amount of repayment?
There's no hard limit in law like there is the protected earnings rate for attachment orders, but Work and Income have a guideline that not more than $40 without the permission of the person. I see far too many people paying back more than $40 who never gave permission. It really should be the least amount the person can afford. And if that is nothing, then it is nothing. It is zero. If it is zero, then it is really, truly, honestly okay for that person to repay nothing. All the time. Like, technically only temporarily, but it can be for as temporary as needed. And if that, I mean, it's a bit like temporary additional support, and most people are on that for years, forever. So, but the reason it's temporary is because MSD don't have the power in law to not recover a debt. They used to, but not anymore. So if the person's paying back more than what they can afford, then they really can repay $1 or $2 or $3 or $5 a week for all of their money owing combined. Oh, has to be $1 per debt, or you'll bloody pay back what I decide. Not that I've seen that very often, which is good. It's just utter legal fiction. The minimum amount that doesn't cause undue hardship. Right. Any other questions? No? Okay, I'm surprised. Usually I'm mobbed by people.
Right throughout.
Hey?
We get throughout.
Oh, okay. Okay. Right. I hope that's been helpful for you. Thanks for